Good afternoon. Hi, everyone. Welcome. We'll get started here in just a moment. And as the screen says, if you'd like, please introduce yourself in the chat. Thanks for joining us this afternoon. In just a couple moments, will be beginning with some information about our other education events. And just so you're aware, all of the links to events that I'm going to talk about will be sent in the chat, and you will also receive the recording and the slides later this week after this webinar. So no need to worry about taking notes. Thanks for joining us this afternoon. As it says, just introduce yourself in the chat. We'd like to know who's joining us. And I'll just go ahead and get started. So my name is Shelby, and I'm the event coordinator here at VOYCE. My email is just down there at the bottom of the screen in case there are any questions about VOYCE or related to our education programming. You can always reach out. And so we appreciate you joining us this afternoon to hear about guidance on guardianship and public administration. This is part of our community education webinar series. And so that just means that this is free information available for anyone who's interested. And we appreciate you joining us. And going along with free education, we would not be able to do this free education without our education sponsors. So I just want to go ahead and thank them for their support. We have Eamon, Gantner, and Capriano, Your Estate Matters, LLC, Enterprise Bank and Trust, Everspring Pharmacy, FDC Foundation, Infinium Pharmacy, and Quinn Estate and Elder Law. I also have our Development Director, Vera Jones's contact information on the screen in case you ever have any questions about sponsorship opportunities. And going along with our community education webinar, we are providing free education to empower individuals and their families to make better informed decisions about the continuum of care and better understand those personally and professionally connected to aging adults. So please join us for free webinars monthly. If you're interested in the topics listed on the screen, such as safety interventions for dementia, communicating your final wishes, aging in place, benefits and costs of that, and caregiver burnout and compassion fatigue, and tons more, we've got all of that coming up. So we'd love for you to join us. Next, we have free in-person education at the St. Louis County Library. And coming up in October, our topic is Legacy Planning 101. These are free to attend, and there is a registration on our website, but the registration isn't required. But these will be happening on October 5th and October 26th at two different library locations, hopefully for your convenience, one in North County and one in South County. So please come out and join us then. And finally, I just want to talk about our upcoming professional development webinar. And these presentations are geared towards those professionals with in long-term care or on the continuum of care. But our next one coming up on October 12th is Residents' Rights Regarding Sex and Intimacy. And this is available for continuing education credit. So we'd love to see you there. This will be presented by David Hassig and Brianna Conley from Paraquad. So don't miss this great information. All right, and so we'll just go ahead and get started with our webinar today. So I'll go ahead and introduce our speaker, which is Paul Gantner. He is an owner of Eamon, Gantner, and Capriano, Your Estate Matters, LLC, and has been there since 2009. And Paul holds a Juris Doctorate and a Master's of Business Administration from the University of Missouri. And he's also a member of the Missouri and Illinois Bar Associations and a VA accredited attorney. He's also a 2022 St. Louis Business Journal 40 Under 40 award winner. So let's welcome Paul.
Great. Thank you, Shelby. Does everything look good? Did the screens flip over? And
let me work on that. Yeah, I believe so.
You can see. Are we good? Is it now me?
All good.
Awesome. Thank you so much. And welcome, everyone. This is kind of an exciting and different topic that I don't really talk a lot about, but many of you are probably interested in talking about guardianships and public administration of guardianships. And many of you know who I am, and those that don't, Shelby did such a great introduction. I'll kind of burn through this. Eamon, Gantner, and Capriano. We're in Sunset Hills, and we do all of the stuff we're talking about today. So, a lot of people think about estate planning like I got to sign some document before I die, and a will is a will is a will, a trust is a trust is a trust, the power of attorney is a power of attorney, and all I got to do is sign some documents, and they're all the same. And that's not really the case. There are really good and really bad ways to plan. And a lot of the stories that we're going to talk about involve people that may have taken some steps towards planning and still found themselves in a really tough place with what we call guardianships and conservatorships. And most people, when they come into my office, they'll say, one of our goals is to avoid probate. And they don't necessarily know why they want to avoid probate, but we'll go through some reasons why, generally, all things considered, we'd rather not be in court than in court if we can avoid it. And a lot of people only think about probate court when somebody dies who gets their money. And the probate court that we're going to be talking about today is more of a living probate. It's you're alive and we're in court to try to determine who can make decisions for you or not. And again, that's something that can be done better ways and less good ways. And we're going to tell some stories about kind of both and what we're, and what we see in our practice and what you might see in your day-to-day lives. So one thing that I'll point out, if I'm here in Missouri, and I think most people here are, but different states have different terminology. So some of the famous stories might use different terminology. But here in Missouri, a guardian is someone who's appointed to act on behalf of another person who can't care for themselves. And it's basically appointed by the court to care for and be responsible for an incompetent adult. And then a conservator would be someone who is appointed by the court to manage the assets of someone who can't manage their own assets. So who can take care of the person is the guardian. Who can take care of the money is the conservator. That's how we talk about it in Missouri. Now, in California, they use conservatorship over both. In Illinois, they use guardianship of the person and guardianship of the asset. So I think it actually works out great here in Missouri to have two different terms for who's got the money and who's making the care decisions for the person. And a guardian and conservator can only be appointed by a court. So one of the things that I'll probably say a few times as we talk today is a lot of people come into our office with maybe somebody at the bank or somebody that they came across that says, oh, just go get a guardianship, just go get a conservatorship. Like it's picking up a dozen eggs at the grocery store and you can just go pick one up. And don't recognize that what we're asking that person to do is petition the court to basically sue the proposed respondent to take away their rights as an adult and have the court appoint those rights to someone else. And that's a scary thing. That's a big step. And that's something that we hope there are good controls to make sure that the worst thing doesn't happen and that somebody gets taken advantage of. And the court does not want to give those keys to the kingdom without having all the doctor's interrogatories, the hearings, the opportunity to discuss those things. So, um, you know, all things considered, 99 times out of 100, we could probably avoid the need of a guardian and conservator by using some form of alternative, like a power of attorney or something like that. But sometimes the person that we're trying to get a guardianship over either doesn't have the capacity to understand signing a power of attorney, or the power of attorney does not. One of the big distinctions between a power of attorney and a guardianship and conservatorship is the power of attorney does not take away any authority of the principal, the person who signed the document. Instead, it just assigns or appoints somebody else who can help. So, the first step that I usually look at, excuse me, the first step that I take a look at when somebody says, "I need a guardianship and conservatorship," excuse me, I'm sorry, I'm getting over a little bit of a cold. Is there a less restrictive alternative? And actually, the court requires the guardianship to be kind of a last resort and the conservatorship to be a last resort. So, could we have this person just appoint someone to help them with their finances or help them with their health care? And the ability to understand what that document allows someone else to do for you, and the ability to do the complex tasks that that person might have to do on your behalf, are two totally different things. So when you say, what kind of capacity does this person have to sign a power of attorney? Well, would I, as a drafting attorney, like to hear that this person has Lewy body dementia? No. Would I like to hear that this person has some other form of disability or diagnosis that would call into question whether they understood what they have? No. But does having those diagnoses mean that that person lacks the capacity to understand, hey, would you like your mom to make decisions for your health care when you can't make them? Like if you needed to get medicine or not, or what the doctors and nurses should do for treatment for you, or whether you should live in this place or another place. That's not a super high level of capacity required. But what a power of attorney does is it grants an attorney in fact or an agent the power to make these decisions on behalf of that principal. Now, if it's immediate upon execution, which most of ours do for finances, then as soon as you sign it, that person can make those decisions. But as I mentioned before, it doesn't take any power away from you. On the medical side, it only springs into effect if two by default or at least one doctor determines you can't make your own decision. So honestly, everyone age 18 and over should have a power of attorney. And I've mentioned on other discussions, Missouri is one of only 4 states that does not have a default healthcare surrogate law. So I know many people out there think, well, I'm married, my wife could just make decisions for me. No, she can't. There's no wife exemption to making healthcare decisions for you, or accessing your IRA on your behalf, or signing your name for an account that you're not on. Well, my adult children can just do it. No, they can't. Well, my parents can just do it. Not the second you turned 18. There is no one that by default can do these things. So everyone should have powers of attorney in place that say, if you can't do it, or even if you can and it's just not convenient, this is the person that I would name. And then you go through decisions. Should I make it as soon as I sign it? This person has the authority, or should I wait until some doctor says that I can't? In most cases, I prefer immediate, and I do want it to be durable where it would continue if I later have an issue. But you can limit the power of attorney to only accessing your safe deposit box on Tuesdays when it's sunny and at least 70 degrees, and that's what it allows them to do. So even if you have a general durable power of attorney, it doesn't include a list of like 12 things that it specifically should say, like making gifts or amending trusts if you want them to have those powers. So The capacity required is they have to understand the document that they're signing at the time of signing. So that is a kind of a necessary, will this work? And if not, okay, let's look into the next thing. Now, guardianships sometimes are necessary. And we're going to talk about some cases where they sound really bad. But really, what the job of the court is to protect this person who may and is alleged to not be able to protect themselves. We can't just assume whoever walks into our office is the good guy, or whoever walks into the court to petition for power over somebody is the good guy. And the court needs to make sure, A, does the person need a guardian at all? And B, if they need a guardian, is this person the right person to serve? Now, the downside of that is it puts the court in control. And what I would prefer is to have the principal themselves choose. If you can't take care of yourself, who do you want? But if they wait until after the significant stroke or after 12 years of dementia and they've never chosen who they want, well, now we don't get to know their vote. So is it the kid who lives with mom, who's always taking care of mom, but also is a 50-year-old that's never had a job and has never needed one because he lives off mom's Social Security and her money, that should be in charge? Or is it the kid that moved off to California 20 years ago, sees her every 3 years, but has never asked for a dime, and she thinks the other one's just trying to take control to steal all the money, right? Like, I don't know. we gotta run those things out. But it does take a lot of time. Again, everybody that comes into our office thinks that it's an emergency and that the court will grant it tomorrow if we go into court with the paperwork. It takes some time. First of all, we got to wait for doctors to get interrogatories back to us. We got to fill out all the court petition. We got to get on the docket, and we got to make sure they don't kick us back to next month and the month after that. All your personal information is disclosed, and it gets expensive. Again, it's not something you can just pick up. You're looking at thousands of dollars for sure anytime you got to go into court. So I'm going to talk a few cases that you might have heard about in the news, and I thought were pretty interesting to talk about. And they're obviously cases of how things might go wrong. But the first one I'll talk about is I Care a Lot. And this is a movie that's on Netflix. I rewatched it over the weekend to kind of remind myself of it, because I watched it when it first came out, I think in like 2021. But it's basically about this woman, Marla Grayson, who is a con artist, basically is proud of the fact that she's one of the people that takes from people as opposed to gets taken advantage of. And she makes a living by convincing the courts that she should be the guardian of elders. And so in many cases with her, even, there are people who may be able to take care of themselves and may not need a guardian at all. But she definitely looks for situations where there's no family around. I think they call them like somebody who's, we got a cherry one here, which means like, oh, good, we got this senior citizen who has no family around, nobody checking on him, nobody who will ask where the money went, and has nobody who can step in and be guardian. Man, this is good. And they have a lot of money, live in a good neighborhood. And what she does is, makes a routine of saying, okay, this person's incapacitated, can't take care of themselves, and places them in an assisted living facility. Well, to do that, she had to have a doctor who was in on it, someone working at the assisted living facility who's in on it. Judges, they didn't really say, or it didn't seem like they were in on it, but they were, they had wool over their eyes, if nothing else. And basically, she would take them with the doctor's information, say they can't live at their house anymore, put them in assisted living with the other person. Everybody's getting their cut. And then she'd sell off all their stuff to pay her high bills she's charging to, quote, take care of them until the money's gone. And so the character in this story, I won't tell you how it ends or the background because you can watch it yourself if you want to. But the character in this story is fictional. Um, I've never seen anything even close to that, of course. But it does highlight the potential that exists when there aren't proper planning and guardrails in place, and you don't have professionals that you can trust and relationships that you can trust. So, I do have clients that say, I don't have anybody. I don't have any kid. We never had any kids. We don't have siblings. We don't have even cousins that we talk to or friends that we would want to put this on. And so I know there are companies that provide services, um, private fiduciary guardianship services, kind of like this person does. But it would require a very corrupt system to do what she does, and it doesn't exist in our system. And I know, as we're going to talk about the public administrator, who is the court appointed person that hired by the court that works in the court, are super overworked, and they do not want to be appointed. And they would much prefer there to be a family member involved. Let me talk a little bit about some of these other famous cases you may or may not have heard of. So in 2014, so basically Casey Kasem, if you don't know who he is, radio disc jockey from the 90s. I know he did a lot of America's Top 40. And well, he was married, had children, got divorced, got married to his second wife, and apparently got Parkinson's around 2007. And by 2013, it became public that he'd gotten a lot worse and that it was actually had some Lewy body dementia. And his daughter from a first marriage was saying that his wife was not allowing his children or any of his friends or other relatives to come visit him in his home in Santa Monica. And it turns out, his daughter petitioned for temporary conservatorship to try to say she's not taking care of him, and she's not letting people see him. And so the court actually granted a temporary conservatorship for the daughter, who had him placed in an assisted living facility in Santa Monica, and then was visiting. Well, then the wife wound up taking him to Washington State, and the court was saying, "Where is he?" The daughter said, "He's been taken. He's missing, and we can't get him the full hearing to have this guardianship and conservatorship." And the wife was saying, "He's out of the country," or the attorney for it, he's gone. He's out of the country. You can't serve him. Well, they found him eventually in Washington State, and there was all sorts of fighting about whether he should be able to have now he's significantly worse. He's bedridden, can't speak. He had artificial hydration and nutrition, and there was debate about whether he should have that or not. And the court originally said you should provide it until a doctor said that it wasn't going to help him. And he wound up dying. And officially the reason was like sepsis and bed sores and things like that. So his family actually sued and had wrongful death lawsuits that were settled in 2019 about this case. But again, it just kind of shows like, I don't want to tell you how many times we've seen this kind of tug of war over somebody who, doesn't have the ability to protect themselves, and just drag to other towns. And I mean, it's just really a sad deal. Again, you can, I'm sure, research more about that. In a room of people, I would usually say, raise your hand if you've heard about Britney Spears. But I know we've got a webinar format here. So Britney Spears is another famous case. In and around 2007, you might remember that Britney was having a little bit of a breakdown. She had some incidents with her children where it was said that she was, locking herself in a bathroom and not letting anybody see the kids or their dad see them. She was driving a car with her kid on her lap. She shaved her head and was walking around public. And so in February of 2008, she was placed under an involuntary conservatorship in California. And her father and an attorney were co-conservators. And that lasted all the way until November of 2021. In 2019, she basically submitted a petition to have her dad removed, and they appointed a corporate conservator. They had an accountant come in, make sure he wasn't stealing from him. But all told, the fees were $128,000 in conservator fees and over $1.2 million in legal fees. And that Free Britney movement and everything came up, that she, came out with the court's in charge of whether or not I can have a child, and, all these terrible things. So eventually the judge in 2021 terminated the conservatorship. But stay tuned, because I don't know if many of you follow a bunch of pop culture, but it seems like she's still doing some things that might call into question whether she does in fact have capacity. One thing that I talk about a lot with clients is you're allowed to make bad decisions if you have capacity, right? Like, there are very eccentric people out there. There are a lot of people that do things that are bad for their health or whatever else, and you're allowed to do that if you have capacity. It's if you're a danger to yourself or others, or you lack capacity, where a guardianship and conservatorship really can come into play. The next one I want to talk about is very recent. Is this Michael Oher case. So if you're not a huge football fan, you might still have seen the movie The Blind Side with Sandra Bullock, and Tim McGraw, I guess, was in there too, about Michael Oher. And Michael Oher was a professional NFL football player, played at Ole Miss before that. But when he was 18 years old, the family, the Tuohys, kind of took him into their house, and according to The Blind Side, of course, adopted him as their son, helped, gave a roof over his head, food, got him to school, helped him choose his college, and they, of course, were Ole Miss alum, and he chose to go to Ole Miss, and they were boosters for Ole Miss, so it was kind of like, was there some conflict in there? Maybe. But just recently, the movie, again, I'm not going to give away the ending, but or the movie, but just recently, in February, Michael Oher says he found out that he was not adopted by the Tuohys. He thought he had been legally adopted, but what they actually had done was gotten a conservatorship over him. And what they told him was, according to his pleadings, are, well, we had to get the conservatorship because you were 18. You weren't a kid. Well, in Tennessee, it's legal to adopt an adult. In fact, in some ways, it's easier because you don't need the natural parent to consent in any way. The 18-year-old can consent on their own to be adopted. Also in Missouri, that's true. You can adopt an adult. But legal adoption and conservatorships are two totally different things. A legal adoption actually takes away the right to inherit from the other family, but gives you the right to inherit as an heir of your adoptive family. Well, the Tuohys, part of their defense of why they never were doing anything to take advantage of Michael Oher is they own a bunch of restaurants and fast food franchises and things, and apparently are worth hundreds of millions of dollars. So they said, well, why would we be taking a cent from him? We don't need it. But they also might have chosen the conservatorship route as opposed to the adoption route, so they can control all of his finances without giving him inheritance rights and actually making him a part of that family. So it's kind of an awkward situation. Well, Michael now is seeking damages, basically saying he claims they got a ton of money from the blind side that he didn't see any of and has used his name, image, and likeness, and that they prevented him from signing his own contracts and agencies and all that. And they basically say, we did nothing of the sort. We've seen no money that you haven't seen. And we'll gladly walk away from this conservatorship. The concerning thing is that this conservatorship has been in place for almost 20 years. They say there's been no annual accountings. And in the initial pleadings in 2008, or whenever it was, when he was 18, I guess he's 37 now, in 2003, the initial pleadings say he does not have any physical or mental disability. Now, I don't know how it works in Tennessee, but in Missouri, you can't get a conservatorship over someone who lacks the ability to make and communicate their own decisions. Now, as I tell clients all the time when they're coming up with their estate plan, do I think 18-year-olds are mature adults who can make grown-up decisions about big money decisions and life decisions? Probably not, but the law says that they are. And you can't just go get a conservatorship because they're 18 if they have no physical or mental disabilities or incapacities. So I don't know how they ever allowed it in the first place. If their goal was just to help him make decisions and contracts and things like that, he could have signed a power of attorney to let him do that and not given up any of his other rights to make money and to have money. And again, if they wanted to adopt him, they could have. A conservatorship, it just seemed like a weird way to pull this off. I don't know. Again, I wasn't there. I don't know if the Tuohys wanted his money. I don't know why they chose that. They say they chose it because that's what Ole Miss or any other college was going to require. But I don't know. We'll see. This one literally has really just been in the news the last few weeks. So feel free to look at that. The guardianships are a good way to protect someone. We do see people that both family and not family that have bad intentions. They say, we got to get you out of the house because we got to sell it or whatever else, or we got to put you in this cheaper place because we don't want you to spend all the money. But a lot of times I see the kids and I experience the kids saying it's not safe for dad to be home by himself. I know he wants to be home, right? I want to grow up and go to a nursing home, said no one ever, but it's not safe. Or we've told mom she cannot drive. She keeps taking the keys. She keeps getting in the car and driving. She gets in one accident a week and we can't stop her. What can we do? Well, you can hide the keys. You can, take things. You can hire somebody to come in. You can put cameras up all over the house in case they fall. You could buy the life alerts. There's things you might look into. But sometimes people are vulnerable. And I want to tell you kind of a few stories of people that through the years have come into our office. And when we thought, the power of attorney is good, but it's not going to work in this case, we really have to get a guardianship in order to protect the person. The first example I'm going to use is Special Agent Ann. This was basically a woman that thought she was working with the FBI, that she got on some list and they were calling her on the phone, and so she was bleeding through her money to try to send it to help the FBI. And then seemingly competent Susan, who, again, you sitting in a room, you'd think totally competent, but unfortunately was subjected to some undue influence and taken advantage of by a family member. And then uncooperative Maggie, who failed to plan at all. And there's no family or support system. And what do? now. So mom and dad did a trust, and some of the assets were funded to the trust, but not all of it. And that's important because, as we'll see, the courts don't have any jurisdiction over the trust assets in a guardianship and conservatorship. So if it's in the trust, the trustee is the person that would be managing those assets. But if it's not, then we'll need a conservatorship. So dad passed away, and as often as the case, mom becomes kind of lonely. Sometimes they can hide deficiencies of each other, and she gets caught up again, believing she's working for the FBI. She's sending cash through the mail to them. They try to change her phone number, and somehow she keeps getting caught up in this stuff. She took out a loan on her car, opened 22 different credit cards with balances. Now over $60,000 in credit card debt, and the son discovered that now she's going to cash in her $290,000 IRA, and comes to the office in a total panic. So what do we have to do? Well, this probably is an emergency temporary guardianship conservatorship situation, because we can't wait 2 months. Mom's going to cash in this IRA and the money's going to be gone. So we showed enough information to the judge that they would grant a temporary guardianship and conservatorship. Still had to go through the normal proceedings, though. Still had to get doctor interrogatories that said she lacked the capacity, examine her, unable to handle her affairs. She could do bathing and dressing and activities of daily living. She just obviously lacked the capacity to handle her financial affairs. So the guardian ad litem, which is a court-appointed attorney, that their job is to act on behalf of Anne in this case. Go out and talk to her, examine the evidence, and see everything that's been reported, and then kind of determine what's in her best interest. And a lot of times when that happens, the guardian ad litem and the attorney for son and the court all kind of see the writing on the wall, and they're kind of like, yeah, she needs somebody to protect her. And at the court hearing, we have to declare all the assets that are in her name, and anything in the trust name is separate because they're not subject to guardianships and conservatorships. So showing all of that, getting the guardian ad litem report, the doctor's interrogatories, the judge did grant, in this case, a guardian and conservatorship was required. So what happens when that takes place? Well, I mentioned in the Michael Oher case, it was kind of confusing because there was no annual reports. When there's a conservatorship in place, these accounts are restricted. Like, I can't access that to buy new bath towels for Anne without the court saying it's okay. Keep good records. Get petitions for any expenses. You have to send in an annual report of any financial stuff. Also, on the guardianship report, you've got to send in an annual report of what the money's being spent on. So again, on the guardianship rules, where is that person living? How often do you see them? What's the nature of the contacts? When do they see their doctor? What's going on with that? Any changes in their care? So again, just to update, that's all been done, has been done for years. Mom did have to move eventually into a facility to pay the expenses at the facility, also had to get approved. So that's a case there. Now, Seemingly Competent Susan is a story where son lives here, daughter lives out of town, mom's diabetic, not taking care of it, making herself kind of worse with her diet. And before daughter can file a guardianship, the son goes around the daughter, files for guardianship and conservatorship. And so there's no pre-planning documents. There's a fair amount of money involved. Daughter discovers son's stealing money, and The house is in need of repairs. The son took out the air conditioner and never replaced it. Um, so obviously, it's a case where we got to figure out who's the good kid, who's the bad kid, and what needs to be done. So we file a petition. You got to get the doctor to say, does this person need a guardianship? Can they handle their own affairs? Get the court to appoint a hearing to represent Susan and have the hearing. And so the result was that mom was deemed incompetent. They did find that son was stealing, and so he's not going to be the guardian and conservator. And since the daughter lives out of state, the court typically isn't going to want to appoint somebody who's not subject to their jurisdiction. So they said you can be co-guardian, but you can't be the conservator. So the conservator was the public administrator. And again, the only downside to that is that the public administrator has hundreds of files that they have to handle. So mom's just kind of part of their job, as opposed to a family member who hopefully, or friend or somebody who hopefully has more of a vested interest in that. Again, a lot of times in these cases, at least in our experience, when they're fighting, nobody's 100% great and nobody's 100% awful in most cases. But a lot of times the court would say, and this was definitely true 5, 10, 15 years ago, was if there's not the perfect person and everybody agrees this person should be the guardian conservator, the court would say neither of you are the conservator. It's the public administrator. I think depending on what court you're in, they definitely have a tendency to rather it be a family member. But since this one, we had somebody out of town, we had somebody who was stealing. It is what it is. At least the public administrator can hopefully make sure that isn't going to happen moving forward. Now, uncooperative Maggie, she failed to plan. She's a widow. She has no kids, no support system, falls at home. Been there 3 days before she gets found. Gets put into rehab. And basically, she's told by the state, you can't go back home. You need higher level care. You can't live at home by yourself. And as is often the case, the house is in no situation where you should be living there. And so, basically, you can't take out the state has to request the doctor's interrogatories. In this case, there's no one petitioning. There's no family. A neighbor asks the court to step in, or asks us to step in to help. So the state's not the guardian. And the court appoints another attorney to represent the best interests of Maggie, and they have a hearing. This person's incompetent. The guardian ad litem agrees. The court appoints us then as being able to serve as the guardian and conservator. All payment requests have to go through the court. And again, we just had to follow the process of what's in her best interest from a care perspective and get everything through the court. Now, in this case, she's unable to regain the strength to return home, had to stay in a facility. Care services brought in help. She had paranoid dementia, no family to come visit. But again, it's one of those cases where it's not always going to be, this is obviously in the best interest. This is not, sometimes you have to protect the person. So I want to share with you kind of some recent developments and then use the last 15 minutes or so, or 10 minutes to discuss any questions that you might have. So feel free to write those in the chat box or the Q&A as well. So kind of recently, there's been some moves to update the probate code. When we say the person lacks capacity, it means even with appropriate services and assistive technology. So that's something that hadn't been added to the code, that maybe there's something that can be done that can make this person who would have capacity without it now have capacity. Also, the least restrictive alternative. So it doesn't mean guardianship should be right away the first thing to do because this person can't take care of themselves. Is there any other alternative? We always want to have this person, to the greatest extent, participating in the community and considering their physical and mental condition and financial means. What's the best situation for them? The term ward is still used some places in law, and I don't like the term at all. It sounds really terrible, but respondent or proposed incapacitated and disabled person is now sometimes more commonly used. The other thing is there's an appointment priority. So some people say, like, does this power of attorney expire? Well, not necessarily, but I usually recommend people to update their powers of attorney at least every 5 years. And part of the reason is there's some laws, including this law, which used to have a 5-year requirement that the power of attorney have been signed in the last 5 years for the agent listed in that power of attorney to be the first person to serve as guardian and conservator. But they said now if it's that agent is listed, then there's no 5-year requirement anymore. So the appointment priority is, can this person say, I want this person to be my guardian and conservator? And provided that the court believes them to be making a decision with capacity, then that would be the first priority. And family over third party too. The other thing is, you will have to go through a guardian or a background check and credit history check at your own expense if you want to be the guardian and conservator, unless you are the spouse or parents or children who are at least 18 or a sibling of that person. So again, another tendency towards family there. If you're a non-family member, make sure you know that that's part of, or if you're thinking, oh, this person should go get a guardianship over that client of mine, make sure they can pass a background check and credit check, or they're never going to be able to be appointed. Again, least restrictive alternative means, could it be something where we don't need it at all? Like, could a power of attorney do it? Could you have a trust and a trustee? Could you make a rep payee for their Social Security? Then we'd go to supported decision-making agreements where the individual, along with other people, are making decisions for supportive services and arrangements as a group. And then, is there any kind of assistive technology? Should we just do this for a temporary time, not forever? Or should we only limit the guardianship and conservatorship to this small window of things? Those are all things that we should look at before we look for a full guardianship. The emergency appointments cannot exceed 90 days. They used to say that you have to have the full hearing within 30 days. Now they're saying 90 days. The hearing has to be held within 5 days of the petition, but the temporary guardianship can stay on for that 90 days. And you have to file a petition for full guardianship and go through all the same processes that we said. Also, when you do the guardianships and conservatorships, if you want that person to be able to marry or to vote or to drive, those are all things that you should specifically pull out, because a full guardianship and conservatorship would not allow for any of those things. Also, it's clear and convincing evidence not only that incapacity exists, but that there's not a less restrictive alternative available. So they always want to say, well, why wouldn't this limited guardian work or something else? Annual reports, you have to include plans for future care, the summary of visits, extent in which they participated in their own decision making, changes in the respondent's condition, a summarized plan for the coming year. Now, if you're like Britney Spears and you want to have restoration of your rights, then that needs to be filed by a court-appointed attorney, the guardian ad litem, a letter from the respondent, or jointly with the guardian and conservator. So again, if the guardian conservator is not doing their job, or if the need no longer exists, that's how you can restore. So kind of in my conclusion, pre-planning is key to avoiding guardianships. Being able to spot when a client's in need of a guardian or being taken advantage of is very important. And I noticed, at least, I don't know how many of the participants here are professionals, but the ones that put in the chat, I know a lot of you work in these situations where you probably come across people that are not your family necessarily, but that you think might be in a vulnerable position. Make sure that anybody who might be in that position can get themselves protected. And hopefully it's before they become disabled or incapacitated. Again, there are things we can do in an emergency once the bad stuff's already happening, but how you're going to be remembered is the planning that you had in place ahead of time and how to avoid that. And that's why everybody should take the time to say, if I'm in this position, then that, because whatever's most important to you should be covered in your plan. And that's why you do some planning. So with that, questions, comments, discussion. I know we got about a little less than 10 minutes, I guess, Shelby, if you saw them come up.
Yeah, we definitely have some questions in the chat and the Q&A. So I'll start with the chat. Someone asked, is there a movement to remove or change the word incapacitated?
Yeah, there is. Incapacitated and disabled is still the terminology for the need for a guardian or conservator. And I know special needs and a lot of terminology is becoming more dated. NAILA, one of the groups that I belong with, and Special Needs Alliance, which ironically is the name of that group, has been trying to push on a nationwide thing. The problem is all of these laws are state, and Missouri is not likely to be in the front of that discussion when it comes to terminology. So, like I said, I thought ward to respondent was a pretty good jump, but we'll see.
Makes sense, yeah. And the next one in the chat is, so does the state or federal government restrict guardianship or conservatorship to only U.S. citizens and residents?
Yeah, so the key is always going to be jurisdiction. So you have to have jurisdiction. The court has to have jurisdiction over not only the respondent or the proposed incapacitated and disabled, but also the guardian and the conservator. So I'm not sure if they're saying that the proposed disabled, incompetent person, incapacitated person was out of the country, or if the guardian conservator is out of the country and they're here. But the answer is no court could appoint any situation where either person were out of the country. They would make, if the guardian and conservator, who I'm assuming is out of the country, they would make you choose somebody who submits to their jurisdiction. So not only in the United States, but in Missouri, in St. Louis County, or in St. Charles County, or wherever you are.
Got it. Okay, so the next question we have in the chat is the cost associated with petitioning for guardianship or conservatorship a flat fee usually, or is it based upon the valuation of the estate being protected? What would the total upfront and ongoing cost ranges be from your experience?
Yeah, so most of the times the costs are going to be based on hourly, unfortunately, in this. Now, I know my firm really hates to do things hourly, so we would try to say, what's going on here? And let's start with this flat fee will get us here. It's not based on a percentage. It's not like probate when somebody dies, where the statute says it's 5% of the first number of dollars, 4% of the next. It's all based on kind of hourly. And then the conservator fees are based on a reasonable fee structure. So again, I've seen I've seen conservators try to wipe out a whole $200,000 estate, saying they spent so many hours and they're getting paid $500 an hour, and the courts are like, no. But obviously, in Britney Spears' case, they showed them approving six figures for that, and then 1.2 million for the legal fees in 1 year. Well, you're dealing with $50 million. You got bigger stakes, I guess. You got a lot of more expensive attorneys spending more hours on it. But I would say an uncontested guardianship, you're probably in our area at looking at at least a few $1,000s total. And if it's contested, you're probably looking five figures or above to really take it all the way in most cases. So,
got it. And then another question in the Q&A is there any way to make a formal complaint against a guardian or public administrator when they are consistently doing things that is against the best interest of the ward?
Yeah, I would make it to the judge in that case if you can first. I don't know that the Secretary of State or anything would get involved in that. I would at least start with the judge and say, here are examples of exactly what they're not doing that we believe is in the best interest of them. And I would probably also show any kind of attempts to notify the public, and contact the public administrator on behalf of the person and say, hey, you're not doing this efficiently. Maybe it's something they just honestly didn't know they weren't doing, or again, that's part of the problem. I wish that wasn't the case, but when they got hundreds of people they're dealing with and they're just trying to get it off their desk, sometimes that happens,
Mm-hmm. I think this next comment in the chat kind of leads into the next question. So someone just commented that law enforcement desperately need training on enforcement of a guardian's rights to have their ward taken for emergency psychiatric hospital admission. Twice they've refused to do this when we as legal guardians have asked for assistance. And the next question is there a comprehensive list of rights that can be used to evaluate potentially if there's a partial restoration of rights to be made?
Let me think about how those questions relate. So I'll try to take it.
First one was just a comment, but just talking about potentially is there a list of guardians' rights?
There's not there might be available on the St. Louis County website. And again, that's just where I practice. I realize anybody here could be anywhere. And I also have some of the other counties, but that's where I usually am. I know when we get the guardianship, the court will give us, these are what the guardian's rights are. The letters of guardianship and letters of conservatorship that the court issues will either say full guardianship, which means everything that person can do on their own, your guardian can do, versus a limited guardianship, which would say it's only this item, this item, this item. So I think that second person's question was if I want to restore some things, but not all the things, is there a list of things that you can do? There is now, I believe, a list. I don't know if it's something that we just made, or I think it's something that's on the court's website, where you can say, what are the things that they specifically want you to think about more, like marriage or voting or driving. Like I said, that specifically, because obviously they don't say they can make pancakes, but they can't make spaghetti, right? Where are we going to draw the line of how detailed all the rights would be that you're putting on? But some of the major rights, those things exist.
Got it.
Yeah, I agree. The police are not lawyers. They're not, they're just trying to figure out how to make this report go away too. And so when they think about having to take a respondent into a psych ward facility, they should know that if you can show them a stamped court, you're the guardian, that's where they should go, because that's the only way that they can get placed. But
all right, and next question is, I'm looking to obtain a power of attorney for 2 elderly siblings. Would this require court intervention? And are Illinois rules different than Missouri? both of the people in question have diminished mental status?
Yeah. So, Illinois rules are different than Missouri, but um, they're all pretty. But in this case, power of attorneys do not have to be court approved. But if you're going to have siblings or anybody else sign a legal document, the key is do they have capacity to understand what they're signing? And that is usually judged by the attorney or whoever's drafting it for them, notarizing it, explaining it to them. If that person believes, even though they have a diminished capacity, they have enough capacity to understand this is appointing my sibling to write my checks for me, to make my decision, whatever the power of attorney is for, then you shouldn't need court for that. That would be substantially less expensive, less involved, and less public. But if it's past that point and they can't make and communicate, they can't understand what they're signing, you might be left with only the option there. And then Illinois does have a default healthcare surrogate law. So without a healthcare power of attorney in Illinois, you may be able to make decisions provided your siblings do not have a spouse, children, or parents living. Sibling would be able to do healthcare decisions. Oh, was I supposed to stop sharing too? I was.
Oh, no, you're fine. Thank you, Paul. That I think will be the last of our audience questions. I do just have a question of my own from watching the presentation. So if people need to hop off, that's fine. But I just wanted to ask for the seemingly competent Susan case, where the son was stealing from the older person in that scenario, would there be was the son charged with any elder abuse financially, or would that be a potential for even just a report of elder abuse by the people who find that?
Yeah, that is a situation where there are elder abuse criminal statutes as well as civil liability. And so, unfortunately, in a lot of those cases, people avoid the civil liability because they don't have any money. That's why they're stealing from mom, and they don't have any assets. That's why they're living with mom. So that's why you got to go through the credit check and everything to be in a fiduciary position, as you don't sue people that don't have money, because even if we show they did it, you can't get anything from them. But I do not recall in this case whether the sister decided to, or mom, press charges on brother or just try to collect back.
Gotcha. And is there anyone in that who was involved in that would be like a mandated reporter of that, or since they're already finding out about it, it's kind of what's the point?
Yeah, most of the times social work is where you're going to find mandatory reporting. If there's anybody involved in that, the state, you're going to be reporting that. But again, whether there's enough, the evidence was there to the court in probate court. But again, whether they decide to pursue it, they kind of want family involved. I had one case where, I'll do this quickly because I know we're out of town, but it explains it. Grandson was caught on video at a gas station buying with grandpa's debit card a bottle of Congress vodka and cigarettes. Well, grandpa doesn't smoke or drink, and the grandson signed the paper and everything. Well, granddaughter, sister of that guy, told on him basically because she found the receipt or something from the gas station, said he's been stealing, and then they pulled the thing. This happened, I think, in Jefferson County. It did, because I got appointed as basically the defendant's attorney, the son's attorney, because pro bono work you have to do when you act in different counties. Sometimes they put you on a list to do pro bono work. So I found out he did do it. I mean, no question about it. He used grandpa's card. It was for $7.88. And, but he did this, and now it's a criminal charge, and now it's kind of in court. So in that case, it wound up that they dropped it because he found out he paid back grandpa, and grandpa said, I don't want to press charges. And I think it was more about daughter wanting to get son and or granddaughter wanting to get grandson in trouble than protecting grandpa. But the real world's silly, you know.
All right. Well, I want to say thank you to everyone for joining this afternoon. Thank you so much to Paul for providing such great insight into this topic. We do have a survey upon closing. We'd love your feedback on that. And of course, you'll receive the recording and slides in the coming week. And this will be on YouTube soon. So appreciate you and hope you guys have a great afternoon.
Thanks.
Thank you.